All right, let's talk about legal research. So, when you're doing legal research, there are two types of sources that you're going to come across. So, the first one we call primary sources, and the second we call secondary sources. So, you have primary and secondary sources. Primary sources are generally associated with what we would call binding authority. And this primary sources of law are what we would think of as the law itself, things that we have to follow. That's why we call it binding authority. Secondary sources are not the law, but they are written about the law, and so they are not binding per se, uh, but they are what we would call persuasive authority. So let's talk about the different types of primary sources. Well, we've actually already covered most of them when we talked about the different types of law. So you'll recall we talked about constitutional law, which can be found in constitutions, both the state constitutions and the federal constitution. There are also statutes, regulations, cases, and I'm going to mention one other one called legislative history. We're not going to get into legislative history in this video, but I wanted to introduce you to the topic. And legislative history is sort of the resources that are created by a legislature in the process of enacting a statute. So these are the five main sources of primary law. Now let's talk about some secondary sources of law. So a big one that you will see are called legal encyclopedias. And there are two really big legal encyclopedias that you should be aware of. One is called the Corpus Juris Secundum, and American Jurisprudence. American Jurisprudence, second edition. Similar to a legal encyclopedia. So, a legal encyclopedia is going to be talking about sort of narrow topics or concepts of law, and giving you sort of a general overview of those. You are also going to have these things called legal treatises, which tend to be a bit more in depth than an encyclopedia, but are not going to give you as broad of a overview of a legal topic. So, legal encyclopedias, you can kind of think of, obviously, they're going to be covering a lot of different topics, all sorts of different topics in law. Legal treatises are going to narrow it down to a more particular subject. So then you can also go into something even more specific than a legal treatise, and you might pick up something called a restatement. And a restatement is, you can kind of think of it as a codification of common law. So Um, if you'll recall, common law is judge-made law, so you have judges in all of the different 50 states making up common law principles, and restatements of law sort of do a survey of all of the different states and their approach to common law topics and puts them into something that resembles a code. Because, as you'll recall, common law, since it's not statutory law, is not found in the legal code of the state. It's just scattered throughout case law. So restatements sort of organize that, and they typically will take when they do the survey of the 50 of all 50 states, and they'll codify the majority rule, and that will give you an idea of how these certain common law principles and rules of law work together. Then you can go even more specific and look at something like a practice book or practice book or practice guide. Um, These tend to be both topically specific, so it's not like a legal encyclopedia where they're just giving you all sorts of concepts of law. It's going to be limited to a particular subject like criminal law or personal injury or contract law. And then also particular with the jurisdiction. So it's not going to be like a restatement where you just get, a majority rule for all 50 states, but actually looking at, for instance, the rules that are applicable in a particular jurisdiction. The final secondary source that we're going to talk about is a law review. And law reviews are sort of so specific that they stop being very useful. Um, so, law reviews tend to um, deal with a subject that is cutting edge and forward looking. And so, a lot of law reviews, and I should also say opinionated. So most law reviews are they're articles that are published in these academic journals. Pretty much every law school, I believe, has a law review. Some even have multiple law review journals. But they publish articles that are written by law professors and legal practitioners and even students that talk about a subject of law, and most of them have some sort of thesis or point of advocacy for how they think that the law should change. And so you're going to get not as much descriptive law. You're going to get a lot of argument that tends to not be super useful in and of itself. But law reviews, if as long as they're written in the topic that you're researching, a lot of times they can still lead you to other primary sources that can still be useful. Other times, if you are dealing with a sort of novel or obscure topic, law review can be, helpful even to cite. Um, if it's kind of the forward-looking law that might help your argument. And so we've got now the main sources of primary law, the main sources of secondary law. Talked about how primary law is generally associated with binding authority. Secondary law, which is not law itself, but is simply um, material that is written about the law, is considered persuasive authority only. It's not itself binding. Um, and generally, the when you move into legal writing, you want to, well, I should say, when you're starting a legal research project, you generally want to start with these secondary sources and then gradually move into the primary sources as you're sort of educating yourself on the topic that you're looking at. And then when you are doing legal writing, you usually want to stick with these primary sources of law and to stay away from secondary sources of law. Not because the secondary sources are necessarily unreliable, but just when you're making when you're writing to another lawyer, you kind of want to have something, you want to become the secondary source for that lawyer. It's not generally that helpful to just cite a bunch of secondary sources. You want to become the secondary source, which means you are looking at these primary sources and applying those primary sources to whatever issue you are researching. Now, I want to also talk about persuasive. Actually, let's do this in another color. So I also want to talk about persuasive primary sources. Okay? So we talked about how persuasive authority is generally associated with secondary sources, while primary sources are associated with binding authority. But it is possible that you have a primary source of law that is not binding but merely persuasive. And let's talk about a couple instances where that could happen. So, first, you can think of sources that are extra jurisdictional. So, one thing that happens quite often is case, you might have a case in the Ninth Circuit. You might have a case in the Ninth Circuit Federal Court of Appeals, and you can't find any cases that are from the Ninth Circuit that deal with your issue, but lo and behold, there is an Eighth Circuit opinion, an Eighth Circuit, let's say Eighth Circuit case law that is on point. Now, a decision in the Eighth Circuit is not binding in the Ninth Circuit, but you might want to cite that case because you don't have anything in the Ninth Circuit that you can use, and that can be persuasive authority to get the Ninth Circuit to essentially adopt the Eighth Circuit's case law. So that's one way that a primary source could be persuasive but not binding. Another way is unpublished decisions. So we talked about how courts of appeals will decide a case and then create a precedent based on their decision, and then that precedent can be looked to in future cases to decide a particular issue that is similar to the decision that created the precedent. But there are lots of times that an appellate court decides not to publish its decision. And when the court decides not to publish its decision, it is not a binding precedent. Okay, so unpublished decisions are not binding. And the idea is basically that, a court of appeals has to decide a lot of cases. A lot of those cases are just going to be repetitive, dealing with the same issues over and over, and so they don't want to overwhelm or just proliferate opinions dealing with the same issue over and over again. They just issue one published opinion for that issue, and then all of the other times that that issue comes before it, they are just issuing unpublished opinions that are, perhaps not as highly edited or carefully written as their published opinions. With the idea being that, they're doing as a quick and dirty job, and um, they don't want the decision to become a binding precedent when they haven't looked that carefully at the issue. And in the olden days, if the Court of Appeals issued an unpublished decision, it was really hard to even find that. But nowadays, the term unpublished is sort of it's a more legal jargon than it is an actual description of the state of that decision. It's fairly easy to find unpublished decisions because they are published on many legal databases, including Westlaw and Lexis. And so you can find those fairly easily, and you just have to realize that they are not binding. They are not binding authority.